Hi, I'm Paul Young, a partner in the firm of Young, Marr, Malice and Associates. Welcome to the Paul Squared podcast. I've been helping clients file for bankruptcy relief and Social Security claims since 1986. I created this podcast to provide an overview of the bankruptcy and Social Security disability process and hopefully answer the most frequently asked questions. My goal is to help clients regain financial stability and support them through the challenging times of either being unable to work or pay their bills due to a disability. While this podcast serves to provide some general guidelines around the practice areas we discuss, you should always consult directly with an attorney to make sure the specifics of your particular situation match up with the various laws within those areas. The decision of choosing an attorney is an important one, and you should give it careful thought before deciding. If you need representation or just have any questions, please feel free to contact me at 215-639-5297 or visit our website at www.youngmarlaw.com. That's YOUNGMARRLAW.com. That's youngmarlaw.com. Thank
All
you.
right. Well, welcome back to Paul Squared, Legal Insights into Criminal Bankruptcy and Disability Law, brought to you by Paul Young and Paul Malice, where we're going to be discussing long-term disability with Paul Young. So welcome back, Paul.
Hi, Pete. Great to be here.
So, Paul, we've talked in previous episodes about bankruptcy, about Social Security disability, your background, but another practice area you have or that you work within is something called long-term disability. Can you briefly describe what long-term disability and a long-term disability plan is there for, and how do you typically get involved in those types of cases?
Sure. But a long-term disability generally involves is when somebody has a policy of insurance, be it most times or oftentimes from their employer, but sometimes they can have a personal policy that they purchased from an independent insurance company that provides for disability insurance benefits, some form of payment if the person becomes disabled. And the policy language, unlike Social Security, it's policy language specific. So it could be if they're disabled from their job or if they're disabled from a certain occupation. But it's a coverage that's either provided by an employer or that you've purchased on your own to cover a disability.
So this is private insurance. This isn't administered through the government or anything like that.
Correct. This is private insurance that's either purchased through your employer or yourself.
And would a good example of this be insurance company that has an annoying duck as its mascot?
Yes, that's one of them.
Okay.
But actually, there's a host of carriers, Unum and New York Life, and so there's a bunch of Standard, Reliance, and they're providing private policies for individuals or policies through more policies than not are through employment.
Gotcha. So in this situation, what we're referring to is it's a private insurance policy, whether it comes through someone's work or they purchased it individually. Some events happen where there's potentially a disability claim, whether it's temporary, permanent, etc. And unlike Social Security disability, where you have to meet a criteria established by Social Security, the actual contract language of the insurance policy itself describes what scenarios will mean that they have to make a payment on behalf of the insured. Is that an accurate depiction of this?
That's exactly right. And I would say the biggest difference is under these private policies, especially the employer-based, they're known as ERISA-based policies. The great majority provide for either a 1 or 2 year period where it's that you're considered disabled if you can't perform that specific job that you were working at. So unlike Social Security, where it might be any job or a job
Right.
that you're, for the first year or 2 years at least, it's that specific job. So that's a key difference with with long-term disability.
So it seems that these are a little more focused, maybe a little more narrowed and definitive. So why would someone hire an attorney for this? Why wouldn't they just file for the policy themselves? What's the situations where you find yourself getting involved?
Really, an attorney, one key difference where an attorney is needed as compared to even Social Security is it's needed much earlier in the process. The reason being, in a long-term disability case, the standard is what's called arbitrary and capricious. And what that means is if it's determined there's even any evidence whatsoever that the insurance company had in denying your claim, then it's valid. Their denial's valid. And the problem is you're never testifying in a long-term disability case. This is through an employer-based policy. So you have to make sure that you're presenting, if you're denied, that you're presenting new evidence, that you're making it so overwhelming so early in the process, because once it's closed and you've exhausted your internal appeals, you're done. You're not testifying anymore. You can't introduce any new evidence. So it's that much more important that someone obtain an attorney early in the process. Well, I'd like to represent everyone in a Social Security case from the beginning. There's times I can step in and still supplement what they've done. If I step in a long-term disability denial and they've exhausted their remedies, I can't introduce anything new. And so the worst thing a person can do is get a denial and just write a quick letter to the employer, or to the carrier saying, no, you're wrong and here's why. Because they're going to rush out and issue another denial, and they're going to say, you didn't produce anything new. We're denying it on the same grounds. So
if they had more medical records or they had other things and they didn't introduce it at that stage, they can't bring it up later and say, well, I had all this stuff.
Well, more importantly, you can't go and get it. Right. So if they denied your claim in a long-term disability context, and they said it's because your particular orthopedist didn't provide enough evidence, you can't though get another orthopedist opinion or another RFC, residual functional capacity, or another evaluation if you just right away say, no, you're wrong and here's why, and they issue another denial. Once you've gotten to the point that you've exhausted those ability to appeal, you can't introduce anything new, and that's very harmful. So really you have to it's almost counterintuitive, even though you're very desirous of getting the benefits, you really need to take a step back. It's even that much more important you obtain an attorney early and say, hey, I was denied, and what can you do for me?
And so it is the situation that most people that come to you with a long-term disability needs are somebody who've gotten denied at the preliminary stages. Is that typically what happens?
Yeah, okay. I would say typically I do get people who are about to apply and they just want the guidance. And I also get people, unfortunately, the most difficult situation is what I just described. I'll get people where they've exhausted their remedies and I have to make a determination. Do I think I can still win with what they've introduced? Because I can't introduce anything new.
Right. You're stuck to the four corners of whatever it is that they've presented at that point.
And then it has to be appealed to court. And then do I think there's enough to go to court with what I have?
So given that it's most common that someone comes to you after the initial denial, and that's when you typically are getting engaged, can you walk through the basic steps of what happens after that?
Sure.
When you're looking to try to get this claim approved?
Absolutely. So what we'll do is the first thing that, again, and I'm drawing a comparison to Social Security because a lot of times there's components that are going on simultaneous. They're applying for Social Security at the same time. The long-term disability, I have to look at the policy. I have to see, okay, what do I need to do under this policy? Is it job specific for a year? Is it job specific for 2 years? A lot of these policies contain language that are job specific, but then after it's job specific, it then says you have to be able to earn do a job where you could earn a certain percentage of what you were earning previously. And in that situation, that makes it a little bit different than Social Security, because if the person was a higher wage earner, it's not enough for them to say you can work doing a Walmart greeter.
Right.
You have to maybe be able to do something at a high level. So I have to define what the limitations are, then I have to look at their medical evidence, and then I really have to assess where are things lacking. Is it that their rheumatologist isn't going to cooperate and isn't providing enough, but even though they have really severe rheumatoid arthritis? And then we decide, do they need some supplemental treatment, some supplemental visits with other people to really fully assess? Typically, what will happen is then after we gather some new evidence, we resubmit it. If it's denied again, then assuming there's only one denial process within the administrative process, we then have to file suit. The difference is, once you file suit in a Social Security case, you're then in a position where it's going to very, very, very rarely is the disability benefits reinstated. It's then usually a lump sum award that either you're going to settle it or a court's going to have to make a determination. And usually at that point, it's going to be projected based on a number of other factors.
And so in that scenario you just described, that second gathering of information is critical, because that's essentially what you're going to have as your ammunition to win your case.
Exactly, Pete. That's exactly right. You're good. That's extremely important. That you're potentially your last bite of the apple, because unlike Social Security, where I could introduce evidence right up until the hearing, and also it is Social Security hearing, I'm going to have that person testify. This person, now I'm basing all this, by the way, on what's called an ERISA policy, since the majority are employer-based policies.
Right.
There's never testimony. It's strictly a written review. I really, because of time limitations, I won't get into too much, but a private policy, you do that proceeds more where you can introduce new evidence. You can testify at a hearing. So it gives you a little bit better chance of success all throughout the process. And I think the whole philosophy behind that is you've paid for the policy.
Right.
Where the other is they're getting it, you're not
benefit
paying.
From work. Yeah.
Correct.
Okay.
Correct.
And from your experience, someone comes to you with an initial denial. What kind of time frame are they talking about to have some resolution to this? And I understand that if you have to file in court, it's going to take a lot longer. But what's been your experience of time frames?
If you're going to win at the appeal level prior to having to file suit, you have 6 months to submit that appeal. Now, you don't want to hold the person up and take too long in submitting it, because obviously, again, the financial hardship.
Right.
But after you submit everything, it usually is anywhere from, I would say, 90 to 120 days before you receive a response.
Okay.
And the responses, by the way, aren't just you're denied. They're going to be reviewed by, if you're denied, they're going to be reviewed by their medical personnel. They're a little bit, because there's oftentimes quite a bit of money at stake. There's a more thorough review, for example, than Social Security's denial.
So you'll have a little more information about why it is they're denying it,
Yes.
to see whether there's countering evidence to that.
Yes. And also, by the way, one thing I failed to mention, I'm sorry, when you were asking about the process, we would normally, in fact, not normally, we would always request the claims file. So when somebody retains us, we request, or even before we make a decision whether we're going to accept the case, we want to see the claims file to see, there can be video that shows something that's really damaging. There could be, and they have to produce it. It's not something where they can say, no, we're not going to give it to you. So a lot of times I'll know where the holes are based upon not only the letter and the medical evidence, but also the claims file.
Because similarly to if they don't hand it over in the claims file, they can't later bring up and say, well, we had this other additional evidence. They're
Absolutely.
also boxed into what they're claiming as their decision.
Absolutely. But it gives us the advantage to know what we have to do if we're going to, and whether it's even something that can be. I mean, sometimes I do get cases where I review the claims file, and unfortunately, I feel like I can't help the person because there's something very damaging that I don't think can be overcome. So other times they'll mention a video, and one that sticks in my mind is I represent a woman who had a actually pretty large claim, and they mentioned the video, and the video was her walking her 6-pound dog. I mean, supposedly this video was going to be so damaging, and it was her, and she had significant back issues, and supposedly walking the 6-pound dog was somehow
their crux of their evidence to deny it.
So realistically, until you saw the video, their denial made it sound like they had video, which really showed that her capabilities were much greater than she was claiming, and it wasn't. So It cuts both ways.
Yeah, for sure. And do you have to be injured on the job for a long-term disability policy to come into play?
No, unlike workers' compensation, a long-term disability doesn't have to have occurred. It doesn't matter how it occurred. It doesn't matter if it's something that's genetic. It doesn't matter, provided that it wasn't a pre-existing condition that you were only it depends on the policy language. But obviously, if you treated a month before you started at the company for a similar impairment, they're not going to cover it.
Gotcha. And does somebody's age matter in this, other than assessing their injuries? Does the fact that they're younger or older have anything to do in the analysis?
That's a good question. Other than not similar to Social Security with transferability, but it does come into the analysis as to the value of the claim, because if they're going to have to pay out benefits for a 35-year-old for a lifetime, the value of that claim in a lump sum benefit, if it reaches that point, is much greater. So that's where it comes into play. But they don't use the same medical vocational grids that the Social Security Administration uses in saying there's less transferability. Their standards usually contractually a little different. It really has more to do with, can you perform work within a certain income of what you were? That's really the bigger question most times. So if it's a cognitive impairment, for example, and you had a cognitive job, if you have a brain injury, you might be able to still stack boxes, but you can't necessarily do a job that pays 60% of what your previous earnings were if they were $150,000 a year.
Which goes back to your point earlier of saying these policies are more driven to, can you do the job that you were doing at the time of the impairment? Well,
that's the beginning portion of the policy. Afterwards, it turns into, can you do any job but it has to pay within a certain percentage.
And that's after the 2-year period?
That's usually after 1 or 2 year period, yes.
Okay.
And the other thing that I should mention, Pete, is because of the interlap between Social Security, there's an offset for these ERISA policies. Every case that I've ever had except one, there was an offset in an ERISA policy for Social Security. So they make you apply for Social Security, and if you're successful, you're going to be offset by that. Now, that's only with employer-based policies. A private policy, you could have paid extra to not have this offset so that you could get both.
Right. Okay. And from your experience, is it uncommon for a claim to be denied? And it sounds like maybe they happen more often on the ERISA level than they do on the private policy level. But I mean, when someone comes in and says my claim's been denied, does that make you say, oh, well, this is going to be a fight here? Or do you just see that tends to be a common tactic that they do?
Well, I would say both, in that you're right. On the private policy level, it's less common. but again, insurance companies, unlike, say, even the federal government, they're really looking at it also with how much they're paying out. So a large wage earner, they're more hesitant to continue benefits or even the grant benefits as compared to, say, somebody who they have less skin in the game. And that's the other advantage of if you're awarded Social Security, they're only making up the difference. So if your long-term disability policy was $3,000 and now Social Security is paying you $2,500, their only monthly outlay is $500 a month. If you were making on long-term disability $12,000 at Social Security, they still have a lot of skin in the game, and they're more likely, not to be cynical, but they're more likely to challenge you at a future date because they have more at stake financially.
Well, if they make you apply for Social Security disability, which seems to have a more strict standard, have you ever seen the scenario where someone's gotten Social Security disability and the private insurer is still denying their claim?
Yes. That's a very good question, Pete. The answer is yes. In theory, it shouldn't happen because in theory, Social Security is the more difficult of the two standards.
Right.
But their feeling is we're not bound either way by Social Security. So, yeah.
So they're going to just claim Social Security made a mistake. That's exactly. We have to do this.
And there's case law that suggests it's a factor that they should take into account, but it's not binding.
Gotcha.
Because in all fairness, they weren't a participant in the Social Security process. So their feeling is, you're right, maybe Social Security made a mistake. Now, I would say to you, the other is more common.
Right.
Somebody's getting long-term disability, and they might never get Social Security because they might never meet that threshold.
Right.
But they meet the long-term disability threshold.
Right. They're different standards, but just based upon how the contract's written.
Yes. And the long-term disability might be that 60% of their previous earnings, which maybe means they had to have had a job where they could earn $90,000 or $100,000. And Social Security is saying that 35-year-old can do a job that it pays $15 an hour.
Right.
So they're not disabled.
Not so concerned about the income versus, where one's driven more so by the income than the other is just, can you do any gainful employment?
Exactly.
Okay. And you've used the term ERISA a couple of times here, and I thought probably worthwhile to just explain what ERISA stands for.
Sure. ERISA is, they're putting me on the spot, Pete. Employer retirement, income. I forget the exact, basically it's an employer-based policy for my purposes for long-term. I know, I should know that, but the employer retirement insurance, I forget but it's basically when it's through ERISA, it's something that's employer-based solely.
Employment Retirement Income Security Act.
Yes. And that's an employer-based, for our purposes, an employer versus a private-based policy.
So, and that's essentially what the importance of seeing ERISA means is that, they got their this policy through their employer.
And the significance of that is, number one, it's a different standard because it's arbitrary and capricious in Pennsylvania, where if it's private policy, it's just a preponderance of the evidence.
Gotcha.
So that's other thing I should mention, Pete, which is pretty important. And I'm sorry to jump between the two. Social Security, I've represented claimants throughout the country because I don't need to. I could request a hearing in any state in the country. For a private disability policy, I could represent anyone anywhere. But obviously, filing suit is in federal court, so you have to be licensed in that state. Yes.
Okay.
So, but if the company does business in the state you're in, you could still bring. So, most of the major carriers do business in Pennsylvania or New Jersey, so I could still file suit here, even if the person lives in. I have a person now who lives in Louisiana.
Or I would imagine that if it got to the point where you had to file somewhere federally, you would could find counsel to work with in one of
Yes.
those jurisdictions.
Although usually what happens is, without getting too technical for this purpose, they'll usually not object. And so they could ask that it be removed to Louisiana, let's say in this case, but they usually don't because there's no reason to.
Right.
They usually just defend it here.
Yep. And a few things related to, someone who's gotten or going through this process. Do they have to let the company's doctor, the insurance company doctor, examine them? Does in an LTD scenario, do you have to submit yourself to independent medical exam?
You do, but they usually, surprisingly, don't request them. They usually do more paper reviews. They do sometimes, but I found that they usually will just have. It's almost as if they don't want to. It's almost as if they'd rather say it based upon their own internal, whether it's an internist or an orthopedist or depending on the condition. He reviewed the records. They'd rather punch holes in what you've submitted but they do occasionally. They certainly do have independent medical exams, but not. I'd say it's less than 50% of cases.
Okay. And if someone's able to return to work, I think you mentioned this already, but if someone's able to return to work, that doesn't automatically mean their benefits are gonna stop here. It goes back to whether or not they're doing the same job.
Well, this is a little yes and no. It depends on the policy. Okay. Because again, it depends on how the policy's written. Unlike Social Security, it's really going to, if the policy says there's definitely going to, if you're only earning a very small percentage of what you were earning, there'll be an offset. But remember, they then are more likely to say you're capable of doing other type of work. So it becomes, if you're just underemployed.
Right. And I guess it also depends on, are you in this 1 to 2 year period or afterwards as well?
Yeah, the 1 to 2 year period is a whole different, ball game, so to speak, because really it depends on what your job was. And oftentimes that's the most, before Pete, you were asking, when do I see a case?
Yeah.
The most common time is after that 1 or 2 year period has lapsed and the person was receiving benefits, and now they received a letter from Prudential or whoever you want to name, who that now says, we've determined you no longer meet the criteria.
Right. They're past that initial more stringent period where they have to pay them, and they're now saying that we're not going to be paying you into this long term.
Right. And in fact, sometimes people are under the mistaken impression that I'm only covered for benefits for 1 or 2 years. Right. Not that they don't meet the threshold, that's all the policy covers.
So how does someone's age play into then a long-term disability policy? Does something really happen when you turn 65?
No.
Okay.
I'm sorry. I apologize. I jumped the gun to your question. It comes into play, again, policy specific. If it ends, if the benefits, some end at 65, some end at 66, some end at 70. But even if it didn't, now, if it doesn't end, I don't know why somebody would do this, but if it doesn't end, they were denied, let's say, Social Security disability, and there's this offset. If they decided to take retirement, there would be an offset against their long-term disability policy. Not to get too technical, but I don't know why they wouldn't just wait until whatever age these benefits end.
Right. But generally, most of these policies have some definitive age in there where they say they's cut off.
All of them do. None. I haven't come across any that have gone higher than 70. The majority are somewhere between 65 and 67.
Gotcha. All right. Well, we're close to wrapping up, so I have sort of one couple questions here. So, how much does it cost to hire an attorney to represent someone in the long-term disability?
Now that really is a little bit different than Social Security. Personally, our firm handles them strictly on a contingency as well. The reason I say it's a little bit different, there are some firms that'll do it hourly. I never felt comfortable because that's usually a time when people don't have the financial means to start. Why it differs, though, is it's not a set percentage because the variance of the dollar amount that they might be receiving is so significant. So
Right.
sometimes we'll do it on one. It's something we evaluate based on a case by case basis, but the way we handle it, it's always a percentage of outstanding benefits.
Gotcha. So it's one of those same scenarios that if you're successful, they pay. If not, they don't.
The way we handle it, yes.
Yeah. Okay. And so as we wrap this up, can you give some general advice or talk about some of the biggest mistakes you see people make when they're trying to, navigate this long-term disability process?
Absolutely. I can come up with a couple right off the bat that I think are very important. One is, again, if it was me, I think it's extremely useful to even consult with an attorney when you're ready to make a claim, to understand what your policy provides for, so you know what you're facing. The second thing is, if you do at any point receive, whether it's an initial denial or you've been on benefits and they're cutting you off benefits, don't react and contact the insurance company with an appeal. Just absolutely consult an attorney at that point.
Right.
It's extremely, extremely important that you not do that. The third thing that I think is really, really significant with long-term disability is somewhere along the way, you're going to be required to apply for Social Security disability. If I could stress real briefly, do not use an attorney suggested by your long-term disability carrier. They have agencies that they use, and for various reasons, it's a natural conflict of interest. If I'm referred all my cases by, let's say, Prudential or Cigna or Unum, they're referring me all my cases. I'm now representing you, and I see something that I think could really benefit them. Am I going to be representing you, or am I going to pass along that I think there's a natural conflict? The National Association of Social Security Attorney Representatives have written a bunch of stuff. Years ago, they never did that. They've started these organizations, and I really believe it is for self-serving reasons. So I would be, whether it was our firm or some other firm, I would be represented by an independent attorney for Social Security, even if you're receiving long-term disability benefits.
So the long and short of it is you should get an attorney involved as early as possible, because there's so many complexities that can hit you along the way that can be a gotcha if you don't do it right.
Absolutely. And the most successful people, and I think the most satisfied, have been people that have done that I've represented.
Well, that's great, Paul. Thank you so much.
Thank you, Pete.
Yeah, for laying out the long-term disability specifics for folks out there. Really appreciate you joining us to give your insights on these various practice areas. We're going to be talking to Paul Malice, who's going to be getting into into criminal law and talking about commonly asked questions and things there. But we really appreciate you joining us on this podcast, and we'll see folks on the next episode of Paul Squared. Thank you.
Pete, thank you.
You're welcome.